Welcome back to our Board of County Commission meeting. We are now moving on to our 130 preset, Department 6, quasi-judicial appeal, consideration of Article 10, appeal by Jeff Dizelle regarding building permit number BLD 201908049 for the replacement of a commercial seawall on property owned by Burr Yacht Sales, Stuart, Florida, LLC. From Krista, and this is prepared by Krista Story. I need to swear in.
No, sir.
I don't need to do that. I need to ask for ex parte disclosures.
If I have any communication, they are filed.
I do, and they've been filed.
I do. They've also been filed. Commissioner Campy?
If I have any, they've been filed.
Okay, Commissioner Hurd. Okay, now Krista Story is going to give us a summary introduction.
Yes, sir. Thank you. So as you've indicated, Mr. Chairman, this is a quasi-judicial appeal under one of the provisions of Article 10 of the Land Development Regulations. On April 19th of this year, pursuant to Section 1012 of the Land Development Regulations, Jeff Dizelle filed a notice of appeal challenging the March 20th, 2020 issuance of a building permit for the replacement of a commercial seawall on property owned by Burr Yacht Sales Stuart LLC and located at 3270 South Canner Highway in Stuart. On May 27th, 2020, pursuant to the requirements of Section 10.12, Deputy County Administrator Don Donaldson conducted an administrative review meeting and determined after that meeting that the building permit was in compliance with all applicable regulations. On June 18th, Mr. Dizelle filed a notice of appeal pursuant to Section 10.12, initiating this appeal to the Board of County Commissioners of Mr. Donaldson's June 9th, 2020 decision. Pursuant to that section of the Land Development Regulations, the board was required to consider the matter within 30 days of the filing of the notice of appeal, so therefore it was scheduled for your meeting today. Because this request involves application of a policy to a specific development application and the development site, it is a quasi-judicial decision. However, pursuant to Section 10.12, the board acts in an appellate capacity, and so therefore we have this slightly different procedure that we're following today. The consideration of the appeal pursuant to the code is limited in terms of who may participate and in terms of what may be presented and considered. Only the appellants, which is Mr. Dizelle, and any representatives, the county through its representatives, and the applicant, in this case Burr Yacht, through its representatives. This type of appellate proceeding does not include an opportunity for public comment. It's limited to the parties. The participants must limit their presentation to the facts and evidence which have already been established, the record. The record in this matter, which was included in your agenda summary, includes the building permit and the June 18th, 2020 notice of appeal filed by Mr. Dizelle. Based on the type of proceeding, as the chairman's indicated, there is no necessity to swear in any participants. This is in a sense legal arguments, not necessarily to be made only by lawyers, but that is the characteristic of this type of proceeding. Pursuant to Section 10.12 E3D, the standard of review by the board for this matter is as follows. Whether the Deputy County Administrator accorded procedural due process whether the deputy county administrator adhered to the essential requirements of law, and whether the final action of the deputy county administrator was based on competent, substantial evidence. So how do I provide guidance to the board regarding those matters? Determining whether Mr. Diesel was accorded procedural due process means that the board should decide whether the deputy county administrator's review of the building permit was conducted fairly and impartially according to all the applicable procedures. Those procedures are set out in Article 10. In determining whether the county administrator adhered to the essential requirements of law, the board should determine whether he applied the correct provisions of the law when making his decision, and that would include any applicable statutes, administrative rules, the county code, the comprehensive growth management plan, and the land development regulations, and that he did not abuse his legal authority in making his decision. And determining whether a decision is based on competent, substantial evidence means that the board must review the record and decide whether there was sufficient evidence to support Mr. Donaldson's decision. At the conclusion of these proceedings, in which all the parties have an opportunity to make a maximum of a 20-minute presentation to the board must render its decision by a written resolution. A draft resolution has been provided in your packet. It has been structured because the staff's recommendation is to uphold Mr. Donaldson's decision. It has been drafted in that way, but there provides opportunity. If the board feels otherwise, then I will ask you to make some other conclusions, and then the resolution would be adjusted accordingly. So, Mr. Chairman, that is just the overview regarding the process, and I'm happy to answer any questions. Otherwise, then if not, the next step in the process would be Mr. Diesel's presentation, and Ms. Christ is going to, once he starts, time it for 20 minutes, and then after that, the board would have an opportunity to ask questions.
Okay. Does anybody have any questions or clarifications for? Okay, with that, Mr. Dizelle, I believe it's Dizelle.
Giselle, I may have been mispronouncing it all
Yes.
along, and I apologize.
Is it possible to sit?
Sure.
Absolutely. There's a stool right here. If that's not comfortable.
Chair, okay?
Here, bring a chair. Yeah.
I think, yeah, fine. Can I take this off to talk? Is that all right?
Yeah.
Thank you for your time and consideration on this appeal. I know you have 216 pages of information in front of you regarding this appeal. The information we were given begins on page 691 and ends with page 907. We were told that all the commissioners had the exact same packet, and hopefully that's true. Starting on page 693, under 123, it states that the Board of County Commissioners must decide whether the Deputy County Administrator's review of that building permit was conducted fairly and impartially according to all applicable procedures. We believe Don Donaldson did not review the appeal in its entirety or did not have the time to completely review it, as evidenced by his June 9th response. His response is on page 706. As far as being impartial, Don Donaldson works in the same 4 floors with the same employees who approved this permit. He He has associated with some of them for probably 20-plus years. We believe as nobly as he tried to be impartial, it was impossible. On page 694, under essential requirements of the law. So of the 12 or so items pointed out in our appeal, essentially he commented on one of them. The next paragraph down, this was explained by stating the review was limited to a consideration of the applicable state statutes, administrative rules, as well as the county code comprehensive growth management plan and the land development regulations. It would not be appropriate for the deputy county administrator to consider policies or objectives outside of the four corners of the applicable laws. We believe we certainly stayed within the four corners of the applicable laws. We referenced the Martin County Code, the comprehensive use plan, as well as the land development regulations in several of the issues on our appeal, of which in Don Donaldson's June 9th response, he made no comment to most of those. A little further down on the same page, under competent substantial evidence, it says many of the issues raised by Mr. DeZell in his notice of appeal were outside the scope of the law applicable to the review of the building permit for the seawall and accordingly could not be considered for the deputy county administrator. This was not just a seawall permit. For clarification, on page 835, the email from Paul Schilling states, on February 17th, the applicant, Burr Yacht, revised their submittal to be reviewed in accordance with the waiver provisions found in the county land development regulations for commercial marinas. On page 855, you will see the permit. If you scroll down to the scope of work, it states February 17th of 2020, scope update, commercial marina redevelopment and reconfiguration. As you can see, the issues in our appeal dealt with the commercial marina redevelopment and reconfiguration. And since we only have 20 minutes, I will try to cover some of the specifics that we stated in our original appeal. Turning to page 756, under 4.5B6 of the land development regulations, it states, under A, no shoreline hardening system shall cause the erosion of abutting properties to be accelerated by the establishment of the applicant's riprap or seawall. It shall be the responsibility of the property owner who has constructed the riprap or seawall to remediate such accelerated erosion activity on adjoining properties, and the applicant shall state such responsibility on the plans. This was not done and should be corrected before this permit is accepted by the Board of County Commissioners. The next two items go hand in hand. The permit allows expansion of the basin width by 10 feet and shows 7 of the 10 feet towards the south. The basic premise of the land development regulations is to rebuild in the least damaging way, and since this permit was changed from a simple seawall replacement to a commercial marina redevelopment and reconfiguration, it appears some very subjective interpretation of section 4.5G, allowing removal of 50% of this applicant's riprap. This riprap fronts the St. Lucie River, which is not a man-made canal. This riprap protects the shoreline by dissipating the boat wakes and providing a marine habitat for fish, crabs, and plant life. Chapter 8, the coastal element of the Martin County Growth Management Plan, references Chapter 9 under Shoreline Performance Standards. It states, wetlands shall be protected as described in Objective 9.1G and as used in this policy, navigable shall include the following estuarine river systems in Martin County: St. Lucie River and Loxahatchee River, including the canals. Scrolling down a little further to number 7, under 9.1G, waivers and exceptions, see page 703 from our appeal, which we referenced. In Chapter 9 of waivers and exceptions, it states, in all cases where wetland alterations are allowed, the least damaging alternative shall be chosen. We pointed out by not increasing the size or just moving the enlarged basin 7 feet to the north towards their own property, this will preserve 90% of that much-needed riprap. It will also conform to the least damaging alternative. When we questioned this, Paul Schilling responded. His response is on page 836. It states, any incidental impact to the shoreline to facilitate the proposed construction on the applicant's, which is Burr Yacht, property are authorized. 50% of the riprap is hardly incidental. And the land development regulations clearly states in all cases, the least damaging alternative shall be chosen. Next, turning to their highlighted pages, which are in your packet, page 762 and 763, under 4.5G, commercial marinas. This is also the section, as mentioned earlier in Paul Schilling's email, shall be used for the February 17th, 2020 change to a commercial marina redevelopment and reconfiguration. Under A, impervious surfaces and other encroachments into the shoreline protection zone may be relocated provided there is no net increase of square footage of impervious surface. The permitted plans show approximately 3,300 square feet of impervious surface conveniently disguised as a seawall cap. That's 2,800 square feet more than existing. This does not include the a la carte permits to follow, including the dock house, retaining wall, and their paver bricks. Just because Burr Yachts has enough money to pour a patio 2 feet thick with concrete, don't let them fool you. Hold them to the code. Further down on page 762 under 4.5G, letter C, existing commercial marinas shall maintain existing access through the shoreline protection zone for water-dependent uses, and in this area shall not be limited to 60-foot wide access, provided the properties designated for marine waterfront commercial use, which it is. Number 1, where development of existing commercial marina development requires relocation of boat entry facilities, access through the shoreline protection zone may be expanded beyond existing access where clear need is demonstrated. Why was Burr Yacht issued a permit without having to do this? No clear need was ever demonstrated in their documents. Next, under 4.5G, letter D, which is also on page 762, commercial marinas with existing man-made boat basins or boat cutouts may be allowed to reduce or eliminate the man-made basin, provided there is no impact to wetlands, seagrass, or oyster beds. Elimination of the basin shall not permit the creation of upland area waterward of the natural shoreline prior to man-made impacts. Please take note, in that paragraph, it says, may be allowed to reduce or eliminate the man-made basin. It does not permit digging it out and enlarging it to create more navigable water. This permit was approved in addition to allowing 10 feet in width for access. It's also allowing 5 feet in length by cutting away the additional 5 feet of land to the east. Where is Burr Yacht's authority to excavate landward and increase this basin in length? This is bad for river flow. It's not permitted by the Martin County Land Development Regulations for for commercial marinas, as we pointed out. Please require this basin not to be increased in length as per your land development regulations, and if they justify widening the access to 70 feet, question, what is the definition of access? Does this include the entire marina length, or does it mean access? It's a very subjective interpretation of 4.5G commercial marinas. At the very minimum, please enforce the land development regulations stating in all cases where wetland alteration are allowed, the least damaging alternative shall be chosen. Do not allow Burr Yacht to damage and remove 50% of that riprap. Another item that should have been required prior to issuing this permit is the retaining wall on the south side of the property. This is a wall capable of holding back 4 feet of dirt and is part of the February 17, 2020 Marina Reconstruction and Reconfiguration scope. However, the only sketch that we have ever seen, and is not even part of the original permit submittal, was a wood slat wall which water would flow right through onto our property. Another example of an adverse effect to our property, which was stated in our appeal on page 708. See page 880, line 23 through 25. On 880, this is the engineer speaking. He used a wall which is not even on the plans in his calculations to retain water on the site per Martin County requirements, which is per the revised scope. Going to page 857, number 4, retaining wall permit. When we asked about this to Michael Uazi, they added a clause that it must be shown prior to permit issuance, and 1 week later that requirement mysteriously disappeared and allowed them to submit for a separate retaining wall permit. If their engineer is using this wall in his calculations, it would only seem necessary that it should be detailed on the plans and verified by plan review. The sketches emailed to us by Michael Uazi certainly would not have kept the water contained on their property. This wall is part of the seawall, it's part of the water retention, and should be shown on the plans prior to allowing this permit to go through. It's time to stop the a la carte permitting. The one item that is possibly outside the 4 corners of the applicable laws, which was mentioned in the agenda summary, considered new information and something every commissioner wanting to protect our river should be interested. The fact Burr Yacht plans to dump their spoiled dredge material on top of the main septic system for this property, which happens to be less than 10 feet from the reconfigured commercial marina basin, and this spoil with the septic effluent will leach directly into the St. Lucie River under their shallow yellow turbidity curtain. Then, after removing the spoil, the very same area is to become Burr Yacht's retention per the approved plans. This septic system should have been shown on the survey of February 20 when they changed the permit from a seawall replacement to a commercial marina reconfiguration. It's time to require the removal of the septic prior to the Board of County Commissioners allowing this permit to go through. Let's not keep our heads buried in the sand. Let's not keep damaging our river and stop Burr Yacht from polluting our waters. We realize legal counsel has recommended you adopt the resolution affirming the June 9th decision by Don Donaldson. But please consider not only the environment, the river, but the blatant violations of the land development regulations and the comprehensive use plan that we've pointed out, especially those in 4.5G commercial marinas. These blatant violations empower you to stop that permit. Clearly, Mr. Donaldson did not have time to review our appeal, and that is why his June 9th decision was so brief, which violates procedural process by not addressing the entire record. Your alternative recommendation is to at least find out the facts and require a resubmission with corrections for this permit. Please do not be intimidated by Yacht's expensive attorney and pack of engineers, and do what's right for Martin County, the river, and the average Martin County resident. Thank you.
Any questions for Mr. DeZell? Seeing none, thank you. Staff's presentation.
Yes, Mr. Chairman, I have a few comments in response. So, as I indicated, the board's appeal and determination relates to procedural due process, essential requirements of law, and competent substantial evidence. One of the items Mr. DeZell pointed to was the fact that Mr. Donaldson asked questions of county staff during the administrative review proceeding. Section 1012D of the Land Development Regulations specifically provides that the individuals to be present at that meeting are the applicant, the appellant, and county staff, and it was therefore appropriate for those who reviewed the permit to be present and subject to questioning by Mr. Donaldson. The staff perspective is all elements of procedural due process were followed. Regarding the essential requirements of law, one of the items Mr. DeZell mentions is that in the appeal, there were 12 items mentioned, and that in determining how to respond, Mr. Donaldson indicated that he was upholding the issuance of the building permit and did not go into an elaboration of a point-by-point discussion regarding those items. It would not have been appropriate for Mr. Donaldson to consider policies or objectives outside of the applicable laws. It is always the appellant's burden to establish that the applicable laws were not considered or applied correctly. So Mr. Donaldson conducted his review, and we do not believe Mr. Diesel has met his burden of indicating that the essential requirements of law were not followed. In Mr. Donaldson's June 9th decision, he indicated that I have considered the record and the presentations made at the administrative review meeting and determined that the building permit is in compliance with all applicable regulations. During that review meeting, Mr. Donaldson heard a presentation from Mr. DeZell, a presentation from Mr. McCarthy on behalf of Burr Yachts, and he asked questions as he deemed necessary. That matter took approximately, I believe, an hour and a half, and you have a transcript of the proceedings that was provided by the applicant's representative. Mr. Donaldson asked questions of county staff, and he even gave Mr. DeZell an opportunity to question representatives of Burr Yacht, and they complied with that request in a cordial effort to provide additional information regarding the building permit. Many of those issues, again, were outside of the scope of the applicable review, and they could not be considered by Mr. Donaldson. Mr. Donaldson's decision was based upon a review of the written record and the presentations. Between the time of the administrative review meeting and the issuance of the decision was May 27th to June 9th. Mr. Donaldson also had those materials prior to the administrative review meeting. The assertion that there would not have been sufficient time to review the record, I do not think is correct. And there has been no, Mr. Diesel has not met his burden of proof required to satisfy the prong that this decision was not based on competent substantial evidence. So for that reason, yes, your staff is recommending that the decision be upheld, and the resolution reflects that accordingly. And if you have any questions of either me or county staff.
Any questions for staff? Okay. Then we'll move on to the applicant's presentation. Mr. McCarthy.
Thank you. Terry McCarthy, representing the applicant, Burr Yachts. Whoever is controlling the screen, can you turn to page 3 of staff comments? Yes.
I got it. Okay, sorry. Is this?
There you go. Just scroll down just a bit further.
Nope, too far, sorry.
You lost me.
A little further?
Back to where you were previously.
I'm not sure. Where are you looking for?
You gave the 3 requirements. Here you're expanding upon them. I simply would like to see the 3 requirements.
Oh, I'm sorry.
Use
Okay.
the middle of the mouse, that scroll button.
Oh, gotcha, sorry. I apologize. Okay, all right. This is, all right?
Keep going back. Going reverse. Page 3, you can, I believe it's paginated. There you go. There you go. Page 3, go right up.
I'm up, I'm 693, yes.
A little more. There you go.
Sorry, I apologize for being technically incompetent.
That was simply a test.
I failed it.
Again, Terry McCarthy representing the applicant. And I remind you, as Krista did, that you're in an appellate court today. The purpose today is not to rehear this case. It's already been heard. It was heard by the hearing officer, Mr. Donaldson. The issues you have to decide are these 3. Did the hearing officer, Deputy County Administrator, accord procedural due process? You will note that in Mr. Dizell's appeal to this board for this hearing, Mr. Dizell describes the hearing conducted by Mr. Donaldson as impressive. It was impressive. It was over an hour. The appellant had as long as he wanted to speak. The applicant the same. The applicant presented 4 witnesses. The appellant was allowed to cross-examine all of them and did cross-examine some of them. Mr. Donaldson called 3 county witnesses. Again, the appellant was allowed to cross-examine those witnesses, as was I. So I find it hard to believe that procedural due process was not observed when the appellant himself has characterized it as impressive. Second, did the hearing officer adhere to the essential requirements of law? That is, did Don Donaldson apply the correct law to the facts in this case? I don't know of another person in Martin County, and I'm not talking about staff, I'm talking about the entire county, more qualified to hear this case and know the background of regulating waterfront property and development on waterfront property and applying the correct law to this case. I don't know of any person more qualified than Don Donaldson. And that's exactly what he did. He applied the correct law to the facts here. Regardless of what side I would be on in this case, since it involved a marina on the water, if someone said to me that the hearing officer is going to be Don Donaldson, I'd say, that's fantastic. He's got extensive experience. He knows the law. His demeanor is excellent. He will accord courtesy to all, and he will thoroughly examine the subject matter. So did Mr. Donaldson adhere to the essential requirements of law? Absolutely. Did the final action of the county administrator, was it based upon competent substantial evidence? Well, In these quasi-judicial proceedings, we all know what constitutes competent substantial evidence. The appellant appeared and was allowed to speak without limitation. The appellant did not qualify himself as an expert in anything. He simply gave opinion. That's all it was. The applicant presented 3 licensed engineers, licensed in the state of Florida, with decades of experience dealing with issues such as this. We also had the builder testify. The builder has 30 years of experience building marinas in the state of Florida. The appellant was allowed to cross-examine those witnesses. Mr. Donaldson cross-examined those witnesses. In addition, Mr. Donaldson called 3 members of your staff: Paul Schilling, Michelle Cullum, Darrell DeLue. We all know that those people are qualified to speak regarding those subject matters. And in all instances, both the applicant and the appellant were allowed to cross-examine them. Clearly, the hearing officer's decision was based upon competent substantial evidence. You have the testimony of 7 professionals against the opinion of the appellant. So your decision today falls within those small parameters. It's not to rehear the facts or rehear the case. That's been done already. Was there procedural due process? It was an impressive hearing. Did the hearing officer apply the essential requirements of law? He knows the law better than anybody in this room. Was there competent substantial evidence? I would assert to you that there was. Now, I have all of my experts here. I don't consider this is the time to hear from them, but if you have any questions, we have nothing to hide. If you have questions of our experts, we're happy to answer the questions. Thank you.
Any questions for the applicant? Seeing none, we've reached number 9. Well, he had the opportunity during the staff's presentation when Krista was talking. No.
I couldn't understand what you just said. I'm sorry.
He asked whether Don was going to
I just wasn't sure if we were going to have an I wanted to just wait until I heard from all of the parties if I had a question for Mr. Donaldson, because it's hard to ask a question until I've heard from everybody involved. If that's not appropriate, then it's not urgent, but I just would have wanted to, from my own perspective, wanted to hear both sides and staff initial presentations. And are we not allowed to have a
No, sir.
file?
You have you have your deliberation and decision, so certainly you could ask questions at this point.
Thank you. Mr. Chair, is that okay?
Absolutely.
Thank you, Mr. Donaldson, I appreciate it. All of the parties were speaking of you as though you were not in the room. So for me, I just wanted to ask the person that made the determination. I mean, I obviously know your record and your background as a county employee, but you're also involved on the Florida Inland Navigation Board, correct?
Yes, sir.
So beyond your experience as a county employee and as our former engineer, you do have a background for reviewing the technical issues that are here. The applicant, not the applicant, what is the title for Mr.
Appellant?
Dizelle?
Appellate.
The
Appellate?
appellant.
I apologize. Mr. Dizelle, the appellate, made a presentation that had a lot of technical issues to it, and I understand we're not getting into the scope of the work, but you did during your procedures, correct?
Yes, sir.
Did you feel comfortable with the information that was presented to you?
I was.
Okay. And do you feel, I know you as a reasonable person, so the point I'm trying to make is if, for instance, if we had Ms. Krista as our administrator be the hearing officer, she would be fair and reasonable and can hear evidence but she doesn't have the technical background that you do. So you don't feel, or that I, Ms. Kristen, no disrespect, I would not be able to dig as deep into the technical aspects that we heard, because some of it is very specific. But you felt comfortable with that, correct?
Yes, sir. And I just, if I can expound briefly, is our code is set up on 2 levels. You have a new facility that can be, has guidance, and then you have the rebuilding of an existing facility.
Thank you.
Examples of like the hotel out on the beach. And so there were technical issues related to this, and which is why I asked specific staff questions during the hearing.
Right. My point is that we're only here to decide that the process was fair. Not specifically the details, but that the process was fair. I'm just trying to make the point that it's not like some of this information could have, for lack of a better expression, gone over your head. You were the person in our staff as our former engineer, and also have a lot of experience outside of the county with the Florida Inland Navigational District to hear these things. Now, knowing you just as a person, everyone got a fair shot, correct? We heard from Mr. McCarthy that the appellant made a presentation, the applicants and their representatives made presentations, our staff, you brought forward and questioned them. It sounds like I read through the transcript, but I wasn't there, obviously. It seems like everyone had a fair opportunity to cross-examine or make presentations of information. Whether they agreed or disagreed with the information, everyone had an opportunity to do that, correct?
Yes, sir.
How long was the overall, from the time that you started till the time that it ended?
I would have to defer to Ms. Story's comments earlier, but it was, over an hour and a half, as I recall.
And is that appropriate time, Ms. Story, for about how long these kind of presentations last?
In my experience, this hearing took a longer amount of time because of the nature of the matter and the opportunities given to all parties.
So the concept that it didn't feel rushed?
No, sir.
It wasn't like people didn't have an ample amount of time to make their presentations?
No, sir.
Now, obviously,
Quite the contrary.
someone's going to come out happy with the decision, and then the opposite will be that they're unhappy. But our goal here, we're determining if the process was fair, and that's it, correct?
Your decision is based on procedural due process, essential requirements of law, and substantial competent evidence. Yes, sir. Those
Thank
are the parameters in which the board operates and makes its decision today.
Thank you very much. Thank you, Mr. Chair.
Mr. Smith?
Thank you, Mr. Chair. Would it be possible, can I take a 3-minute break? I just have to respond to something, and I'm not sure what's going on. So can we take a break, or do you have to continue on with this? If not, I'll step out.
Sure. Take a 5-minute break.
Thank you.
Okay, we're back. Where do we leave off? Mr. Cantor?
Mr. Chairman, if I could just correct a couple things that I neglected to mention. First of all, a full copy of the agenda item packet has been submitted to Mary Kay for the record, and I thank Mary Kay and Donna both for reminding me to do that. I appreciate that. The other thing, I did go back and look at the transcript of the proceedings, and I wanted to indicate to you that although the hearing was scheduled to begin at 1:30 based on the transcript, it actually began at 1:38 on May 27th, and it was concluded at 2:40 p.m. So I was I extrapolated a little bit further regarding the time, but I do stand by my comments that hearing was a hearing of greater length than is typically found in an Article 10 appeal. So I'm not changing my perspective in advising you about that. Thank you.
So I've known Mr. Dizelle for quite a while. He's a very intelligent, very environmentally conscious person. I spent quite a bit of time with him out on his site reviewing his concerns. But at the end of the day, that's apparently not what this is about. It's a little frustrating, but anyway, Commissioner Heatherington.
I mean, I would echo some of those. I went and visited with Mr. Dizelle as well, and I do have a question. I understand that we're just looking at procedural due process, but for my edification, the authority to excavate the basin inland, is that something that the county permits, or is that something that the DEP permits?
It would be both.
So there was a DEP permit issued?
Yes.
Okay. All right, thank you.
Anybody else have any? We're supposed to be deliberating. Can we entertain a motion?
Sure, I'll move staff's recommendation.
Second?
Okay, we have a motion by Commissioner Hurd, seconded by Commissioner Smith. All in favor?
Aye.
All opposed? Motion carries unanimously.
Thank you.
Huh? Yeah, no doubt. Okay. Since we have one speaker, at least, for our next item, we'll take that up now. Department 5, if we're prepared to do that. Is Mr. Arthur here? I don't s-
Oh, I saw him.
David Arthur?
You cover the item for him?
All right, is there something else we can do before then?
No, sir, I'll start.
No.
So this is a approval of a license transferring the maintenance
Well, they said he was here. Here he is.
response.
Here. Because we can't hear you.
Thank you for your patience. David Arthur, Senior Assistant County Attorney.
Put the microphone.
David?
Oh, can you hear me okay?
Yes, down we
Okay.
go.
David Arthur, Senior Assistant County Attorney. This is a request for approval of a license between the City of Stewart and Martin County to transfer maintenance responsibility to the county for all parcels adjacent to 18th Street, and to allow the county to erect a perimeter fence around the premises to protect the surrounding airport operations. On or about November 1, 2005, the county, pursuant to the Airport Noise Mitigation Program and a grant from the FAA, passed a resolution authorizing the purchase of all 23 parcels within the cul-de-sac known as Lawler Gardens, adjacent to 18th Street within the City of Stewart. Lawler Gardens and 18th Street are adjacent to the airport, and the entrance to 18th Street fronts Southeast Palm Beach Road. Pursuant to the resolution between 2006 and 2008, the county purchased all the parcels from the individual owners using the funds from the FAA's grant for that purpose. And the county had all structures removed, including the mobile homes, such that the area became and remains vacant. The county intends to keep the parcels vacant to comply with applicable FAA requirements and airport minimum standards. The county, as the owner of the parcels, desires to install fencing around the perimeter of the former Lawler Gardens subdivision for the purpose of protecting the adjacent airport operations area. To accomplish this, the county needs to take over maintenance responsibility for 18th Street from the city, which is a cul-de-sac, by the way. As part of the license, the city and the county would agree to a design of the portion of the fence that would front and is adjacent to Southeast, or would be adjacent to Southeast Palm Beach Road. And the city would agree to cooperate with the county in obtaining any necessary permits and approvals for the installation of the perimeter fencing. The county would install a chain link fence for the perimeter, for the remainder of the perimeter. The county would pay for the installation of the fencing at its own cost or with noise abatement grant funds as applicable. The city and the county would also agree that upon full execution of the license, the county will have the right to exclude anyone from entering the former Lawler Gardens and 18th Street at the county's sole discretion. Finally, the city and the county have agreed that each shall be liable for their own actions and negligence, and to the extent permitted by law, the city shall indemnify, defend, and hold harmless the county against any actions, claims, or damages arising out of the city's negligence in connection with this license, and the county shall indemnify and defend and hold harmless the city against any actions, claims, or damages arising out of the county's negligence in connection with this license, which of course is standard. The city has already approved this license. We've attached the signed license to this agenda item. We therefore move that the board approve the license with the City of Stuart and authorize its chair, the execution of any of all documents necessary to complete this license. If there's any questions, I certainly will answer them.
So moved.
I have a question.
Go ahead, I'm sorry, go ahead.
You said this fence is to protect adjacent airport operations. How is the fence there across the way? What do you mean by protecting adjacent airport operations?
If you look at Exhibit A to the license, you'll see there's a map of it, but if it's on page 685. The runway is very close to this old cul-de-sac. And here, I can get it for you. There you go.
Go ahead.
There it is, right there. You can see that's Palm Beach Road right there. This is 18th Street here. Now, you can't see it, but there's a fence here, and the runway is like right over here. So it's really close to the airport. And so it's important that...
Across from Monterey, correct?
Yeah, Monterey is over here. So it actually kind of diagonals over
Can I
here.
jump in?
Yeah.
Hey, real quick, Sam Carver, airport manager. So basically, all that property is in our runway protection zone. So we have an obligation to keep people from gathering in that area. So that's why we want to put the new fence up, to keep people from going in that area. It's because of its closeness to the runway.
Right now it's open. It's just vacant land, but it's open and anybody can go in there. So we need a fence to keep people out.
So you're going to put a chain link fence around, is there
Right.
a buffer between those houses that look like 10, 11, 12?
Well, there's actually a fence there already. There's a chain link fence that separates the houses over here. If you can see my cursor, you see it starts with 10 and goes over to 18. There's actually a fence there now, so we probably would not have to put up a new fence there. So it's already partitioned, but there's no fence on this side. And Sam, correct me if I'm wrong, but there's no fence on this side.
Yeah, we're going to put brand-new chain link fence on 3 sides. Then on the frontage part, we're going to put decorative aluminum fence with landscaping, which we collaborated with the city of Stuart, making sure it was something that looked nice.
Right, and when we discussed this with the city of Stewart, they requested that we do something like this. I know it's kind of hard to see, but it's a decorative iron fencing that would, or fencing that style that would be adjacent to Southeast Palm Beach Road.
And we were putting landscaping on the outside of the front?
On the inside of the fence.
Right. It's not part of the license,
I'm
but I
sorry, what
think-
did you say?
On the inside of the fence, so it's more protected, but it's going to be something that looks nice.
Thank you.
You're welcome.
Yes, sir, Mr. Campy.
Thank you, Mr. Carver. While we have you here, historically, as we mentioned in the agenda item, this used to be a residential street, but based on something, I guess, some direction a long time ago, the houses were purchased and removed to create a runway protection zone, correct?
Correct.
I know that we're not allowed to put anything there that would draw people or anything. Is there any functional, useful option that the FAA would allow us to have? Anything whatsoever? Anything?
No, and I tried many options. We talked about a dog park. I even thought a solar farm might work there.
Can we
but-
store county equipment there? Can we do anything? It just seems like such a weird
Yeah.
piece of property that's protected,
Right.
but.
I agree. We kept asking, and they have a little bit more opportunity to say no because it was their money that purchased it. So it's not like just normal property we have that's in an RPZ, but because it was their
Stormwater
funds.
retention pond, anything?
No, this has been ongoing since that property was vacant. We even went to Orlando. I don't know, George, were you here then when we did that? We went up to Orlando to talk to the local office there to see if there was anything that we could do. And they've just been very emphatic about it.
All right, thank you. Just wanted to ask again.
I just wanted to add, the federal government spent a lot of money to purchase these homes, and if they're not safe for people to live there, they're not safe for people to recreate there, and I think that's perfectly reasonable.
Oh, I knew that. I just thought maybe we could store stuff.
Nah.
Okay. So did we get a motion? Do we get a second?
I'll second it.
Okay. Mr. McChrystal would like to talk about it.
Good afternoon, Commissioners. Thank you for your time. Right out of the gate, I'm thinking, if we're going to fence off that side of 1230, are there plans also to fence off the other side of 1230, the runway protection zone on the golf course property, and prevent people from getting to the blue course? Or are there plans for something special going on over there? So if we're talking about safety for humans and pilots and jets, if you're going to do something on one side of that runway, it makes sense to do it to the other. So a lot of stuff that brought some questions up for me. So on the one hand, we're asking the city for permission to erect a fence and take over the maintenance. But then further down in the license agreement, it says the county is already the owner of the parcels. So I'm really wondering who owns the land. Does the city own the land or the county own the land? And it says the county will pay for installation of fencing at its own cost or with noise abatement grant funds as applicable. In my mind, there's no way you can ever present this as something for noise abatement. So who owns the land? And is anyone being, after all these years, I've always wondered, is anyone being reimbursed for lost tax revenue of the 22 homes demolished because of the illegal 1230 extension? Why is a fence necessary off of airport property? Quote, for the purpose of protecting the adjacent airport operations. Again, if you're going to do it on one side for the safety of airport operations, it makes sense to do it on the other side. I don't see where you can do it, because you'll cut off golfers from the blue course crossing that area. So there's just a lot of mixed signals. And again, I'm wondering why on the one hand we're asking the city to do something if it's already our land. So that's all. Thank you.
Thanks, Frank. Mr. Arthur, you want to elaborate that?
I think I can clarify. We own the land that surrounds 18th Street. The city owns the street and is required to maintain it. We're simply taking over maintenance so we can fence it off and therefore protect the airport as required by federal, well, FAA regulations.
So the street, not the land.
Yes, correct, the street.
Got it.
We already own the land.
Got it.
But the city owns the street.
Correct.
Okay. With that said, any other questions? Okay, we have a motion, I believe, by Commissioner Smith. No?
Heard.
Commissioner Hurd. Okay. This is a problem with making a motion 10 minutes ago. Commissioner Hurd, we have a motion by Commissioner Hurd, seconded by Commissioner Campy. Smith, geez. Sorry. All in favor? Aye. All opposed? Motion carries unanimously.
Thank you very much.
So George, your item, we have a 17-minute window. Is that something that,
I can obtain that.
okay.
Gotta keep it light.
So Department 8, presentation by the Board on CARES funding, Mr. George Stokes.
Nope. Can do it?
I'll do it. Thank you.
Oh. Oh, okay, all right.
Good afternoon, Mr. Chair. George Stokas, Assistant County Administrator. I'm going to have a brief CARES update for you. Just to give you a little sneak peek, just to bring you up to status as where we are with municipal reimbursements and constitutional reimbursements. We have delivered those MOAs. As of June 26, we have, I believe, the City of Stewart yesterday took action to approve their MOA. I know the rest of municipalities are also undertaking it. I have spoken to most of the constitutionals, but someone from the county has spoken to them, and we do have a couple that are already executed and seeking some reimbursement, so that is moving well along. Social services, we are underway with the United Way for mortgage and rental assistance. Thanks to the governor pushing back the moratorium on rent and mortgage till August 1st. We hope to have this program up and running prior to August 1st. And we're waiting on the United Way to execute their MOA. So we're moving well along with that. Transitional housing, this is where we move individuals who are displaced, the healthy individuals that will be displaced because the COVID-19 individuals will stay in their dwelling. We've already contracted with at least one hotel in town, and we're working towards others as well. Utility assistance, same thing, moving forward with United Way and Health and Human Services. Probably the biggest update from a social service aspect is I was speaking with Mr. Pruitt and the Treasure Coast Food Bank. They have put in a request, which is applicable under COVID-19 CARES Act funding. We have about a $3.5 million request to provide emergency food service from July 1st until December 30th based on the previous quarter spending. And we're working on a memorandum of agreement with those folks at Treasure Coast Food Bank, and we will be probably coming back. We will be coming back to the board with their contract. Typically, with all these services, you see about a 9 to 10% administration fee, which is completely reimbursable under the CARES Act, and this will provide, this will restock all of our local food banks. So that is the one big change. That actually, I got that letter this morning. The big reason why we're here is to talk about small business reimbursement assistance. I know other municipalities have laid out their program. We all seem to be about the same. Again, we're looking at a one-time business reimbursement grant of $20,000. Of course, the business has to be a Martin County business. We're going to require that with an active business tax receipt and registration on SunBiz, and it has to be prior to October 1st of 2019. as well as the businesses are going to, they'll have to still be operating as of August 1st. So if the business were to be out of business in June 1st, it would not be eligible. They'll have to provide a 2018 or 2019 IRS tax return. They have to be for-profit, so this is not for a not-for-profit, but totally for-profit. They cannot exceed $5 million in their gross receipts, and they cannot have received any COVID-19 relief funds in the form of a grant exceeding $20,000. But, for example, if someone got a PPP protection at $10,000, they would still be eligible for $10,000 in county CARES funding. And for example, if a salon owner or a salon person received $1,000 in a forgivable SBA loan, they would still qualify for $19,000. So you're not shutting out businesses, but you are having to take into account. There is a little bit of an issue when it comes to SBA and PPP. We're struggling to get some of the records of which businesses actually did receive it, but we are working with those entities to better home down that, and legal has come up with some options for us as well. The last time I was up here, I also wanted to mention these are the eligible businesses as we see it. Agriculture, child care. I won't go through the entire list, but basically these are the businesses that were shut down by, that were considered non-essential. Anything from your hair salons, medical offices can also include dental, retail is more of the bricks and mortar, restaurants, bakeries, and then we use what, I couldn't tell you what NAICS code is, I just know where to find it, and I know how to look it up. But we will have a staff that will look at all that. So these are the proposed eligible businesses. And these are the type of applicants, sole proprietors, corporations, partnerships, and more importantly, the eligible uses: salary, payroll, inventory, commercial leases, mortgages, rent payments, utilities, and other expenses due to new safety provisions. For example, if they wanted to do PPE, we can do that. This body had asked me to look at what is the comparison of what we're doing compared to others around the state. I apologize because a lot of the counties that I'm using as examples have a much greater population than we do, but they were the first ones out of the gate with a direct access to the CARES Act. Staff's proposing about 20% allocation of our CARES grant, which equals about $5.6 million. We do look to subject to change that based on, are we getting a lot more requests, are we getting less requests? There's a little bit of a shifting, but just in comparison, Broward County, 24%, Orange County, 30%, Palm Beach County, 23%, and then St. Lucie just put in about 30%. So we think we're right about where we need to be when it comes to our business, helping out small businesses. And finally, I want to kind of show you a breakdown. I know that a lot of other municipalities have been putting specific percentage numbers to how they're allocating that. Staff's not recommending that because you want to stay flexible enough between now and December so that if there's a greater need, say, in mortgage and rental assistance, you could be able to perhaps siphon off of some from municipal reimbursement that hasn't been used, or utility and personal need items that haven't been used. But overall, the largest chunk is the municipal reimbursement. That's us reimbursing all the municipalities for all the overtime, PPE, and COVID-19 expenses. Constitutional office reimbursement, probably the biggest, will be the Sheriff's Department paying for all of their time. And it's not just overtime. It's regular salary and benefits for all the time that they've dedicated to COVID-19. In talking with the Sheriff's Department, they had a whole division that did nothing but COVID-19 items for us, as well as like the boat ramp closures, the beach closures. That is all reimbursable as I understand it through the document. 20% for mortgage and rental assistance, and I've gotten those numbers from the United Way based on what they've already allocated, and they seem to be very happy with that number. We may have to tweak some of this a little bit for that food bank requirement, and I'll have to come back to you with more accurate figures on that. 20%, as you know, for small business, and then 5% for utility, personal need, and food assistance. So breaking this down from a staff's perspective, you got 28% going back to government, about, was it 55% going back to government and government offices, another 25% going back to individuals, and then 20% back to actual small businesses. And as promised, Mr. Chair, I think I did that in less than 17 minutes.
You did. I'm very proud of you.
I'm more than happy to answer any questions you guys may have.
That was about 8 minutes. You did good.
Try to be brief and brilliant.
Commissioner Smith.
Thank you, Mr. Chair. George, just a quick question on the larger urban counties that got their money much earlier in the original allocation. Was theirs also tied to the COVID-19 funding that individuals got or businesses got, or was that separate because they fell under a different category?
Everything that I've read from the bigger counties, so if I want to make sure I understand your question correctly, but my response is everything that, yes, it's all been COVID-19 related, but are you talking about the eligible businesses?
No, so in your one screen that you had up that if an eligible business had received $15,000 in PPP money, they'd only be eligible under this program for $5,000 more if they met all the other criteria.
Yes, and the reason why that is accurate, I have two ways of confirming that. One, in the frequently asked question document from the Treasury, it clearly states that you cannot, what we're calling double dip. You can't go and get $20,000 from Martin County and another $20,000 from PPP or SBA or wherever else you got it from. And then on top of that, other counties have confirmed that with the Treasury. I had a discussion with the Deputy County Administrator for Palm Beach County, and this is exactly how they worked it in their program.
Okay, so this mirrors theirs, and they weren't able to get two sources of funding, one from the county, one from the feds.
Right. And truth be told, if someone wanted to slant the system, I'm sure there's a way to do that,
I'm
but,
not- I'm just
for the
curious
most
that-
part, you're eliminating 90-something% of it.
I just didn't know if there were a different set of rules that we fell under because we were in the second set, or if it was all pretty much the same across the board.
We're all on the same set of rules.
Got it, thanks. Thank you, Mr. Chair.
Thank you.
Okay, Commissioner Camping.
Thank you very much. Mr. Stokas, I appreciate the presentation. What about either through some of these funds, or if you could do some research in any other federal or state options for internet connectivity and internet connections? Now, we have a lot of areas in Martin County that have no service whatsoever, and now that students are going to be either as an option or as a mandate having to learn virtually, they have to have the internet connection. Plus, not just for local schools, but for colleges, a lot of our college students are going to be required to take their courses online, and then also employees that are working remotely. That sounds like a reasonable option for a lot of us as we combat COVID, except if you live in one of our blacked out areas in Martin County where they don't have it. I know Mr. Merker and I have had some conversation. I know Jeff Leslie from ITS Fiber, but a lot of it just comes down to dollars, and I think this might be a great opportunity for us to try to tap into some of this infrastructure dollars, because it's not like we're just trying to give people cable television anymore. We need people to have the ability to work and learn from home. So I'd like to push forward on that if we can as well.
And Commissioner, that is an eligible expense under COVID-19. I just wasn't aware of any of those issues, but I'll get with Mr. Merker in your office, and with this board's permission, I'll come back with an update as to options available, if that's okay with the chair.
Absolutely.
Thank you very much.
Commissioner Hurd.
Yes. Have we received or applied for the CARES grant?
We received the initial 25% money, which is about $7 million. It's a reimbursement, so it's not necessarily a grant, but we've received that $7 million. And then what we have to do is my understanding, is start to take off of that $7 million, and at some point when we get close to the end of that $7 million, we go back to the state and we keep asking for more money as a reimbursement, and those monies are then sent from the state to us. So they're kind of holding on to 75%, we're holding on to 25%. They're probably collecting interest.
And where's the guarantee that they're holding on to the 75%?
It's in our agreement, our actual physical agreement that we've signed over, and it says all that money.
So they can't run out before we get our fair share?
I would say no, but I'm going to refer to legal. I don't think they can. I think that it's through the state, through the federal government, they are supposed to allocate.
Happy to look into it. I
Yeah.
can't off the top of
I
my
think
head.
Mr. Donaldson has something to say.
I'm
Mr.
skeptical.
Don Donaldson, I executed the contract on behalf of the board. The funding is there. It is eligible through the end of December. Any unused funds, the state can take it back, or the federal government can take it back. So the money is good through the end of the year. any eligible expenses that we go through the end of the year, I would presume that we would have a couple of months after that to be able to do any final processing, probably March of next year at a minimum. I would also hope that any unused funds, maybe Congress might be able to allow some reappropriation of those funds for something else, if that's, that would be our hope. But so our goal is to spend, obviously, all those funds, make them eligible, and the challenge for us is the guidance has been limited, so as you could see, Mr. Stokas has done a really good job of using others and customizing it for Martin County. So our goal is to try to both document that we spend it properly and spend all of it.
Yep. Thanks.
Okay. Seeing no more questions, thank you. Nope. Ah, I didn't see you.
You mentioned transitional housing. Are hotels the only group that we're working with? Because I know there were some efforts by La Haya and some other organizations here locally. Is that something that they could participate in as well?
I'm not as familiar with what La Haya is requesting. I'm more than happy to look into it, but the transitional housing is to be set up for individuals. For example, let's say you had two very immunocompromised individuals living in the same house. One comes down with COVID-19. The one that has COVID-19 stays in that house, and then through various providers would allow our Health and Human Services Department to know that they need a hotel room. We provide them that hotel room. We're saying like $100. We go and get that room. That individual stays in that room for anywhere from 14 days to, depending on the situation. Once the other person's no longer COVID contagious, I guess if that's a word, that individual then moves back into that household. I'm not familiar with what La Haya is trying to do with this, but that's what the program is. I don't know where La Haya fits in on that.
Well, they've done a couple of presentations. I don't know if this would be applicable, but I would recommend just talking with them and see how they fit into the puzzle.
Okay. Thank you, George. 3 o'clock.
George.
So, what?
Good job.
Yeah, absolutely.
Thank you.
So we have one more item.
Yeah, the executive session, even though we preset it at 3, it was intended to do at the end of the day.
Okay.
So you have one item left that Mr. Mail is
Okay.
here for.
Good afternoon, Commissioners. John Mayle, Martin County Ecosystem Restoration Division. Today I'm providing, sorry, what?
Match the tablecloth nicely.
Yeah.
Well, even more importantly, his mask logo is the most important part of his
Yeah.
ensemble.
Shameless plug for the Jensen Beach Falcons.
There you go. Thank you very
You
much.
too can acquire one of these and support the Booster Club.
Or the Palm City Dolphins.
So today I've been asked to bring a presentation to provide an update on conditions in the St. Lucie River and estuary, and to give a recap of what has happened with the river in light of precipitation events this spring. I'm probably running it here, aren't I?
Yeah, there you go. Go down to number 7. There you go.
All right, there's got to be a way to make
View,
it bigger too.
View, yeah, and that one.
Look at that. So first of all, this is the kind of the daily check-in sheet that shows lake levels and discharge volumes to some of the key structures. This is a week old, so it's not terribly relevant anymore. Today, the lake level is at 12.53, which is about a foot below the average for this day over the period of record. What I would probably point out here is that the Caloosahatchee continued to get about 670 CFS, or cubic feet per second, of freshwater flows through the entire spring, which was at their request to meet the salinity requirements through the range of the Caloosahatchee. You'll notice on the S308 that it's a negative number. We will talk more about that in a minute, but that reflects water going from the C44 basin, which is most of western Martin County, into Lake Okeechobee through the S308. So that's water that normally would have gone to us through the S80 as local runoff, that because of the lake level, they were able to deviate from that and send it to the lake. Again, we'll come back to that. This chart here illustrates the lake level from January 2019 through today. It's the red, blue, and yellow line that's lost in that host of other lines. I guess a few things that I'd point out. We started January 1st at about 13 feet, which is a nice place to start, January 1st, and we got down to a low of 11.00 on May 17th, and that's when the rainy season began this year. The Corps had targeted 12 feet by June 1st as an objective, and because of substantial rainfall in May and June, and particularly dry conditions in March, they came close to that, but not through any type of average circumstances. Average is a word that is kind of meaningless in water management anymore. I'll jump back to this slide and explain these dotted lines that are interesting to us and as stakeholders on the East Coast. This shows the probability of lake level outcome. And of course, as you're very close to today, that the probability band is narrow, and as you get further away, the unknowns become greater influence and it becomes very broad. We had on June 1st a 50% probability of being at about 11.5 today, and as you can see, we're much higher than that. We followed more than 90th percentile in that probability, and today when we look at probabilities going forward, probably the most relevant statistic is the probability of Lake O discharges to the St. Lucie River is between 0% and a maximum of 20% by the end of the rainy season. Now, of course, any tropical activity that comes our way substantially moves the needle on that. But if things continue as they are and the forecast is more or less 50-50 for average precipitation for the rest of the wet season, we would expect not to have any discharges during the rainy season. Again, this shows what happened in March. We had the driest March on record in the entire district. All that red is on the bottom of this chart at less than 30% of average rainfall. That really drove this, the lake level here from this base flow band almost to the bottom of the beneficial use band. We flirted with the water shortage management band, but never crossed it this year. Last year, we crossed it just for a day or two as we got into the wet season, or halfway through the wet season. That August rains really drove this up last year. And then, of course, the big rainfall came for us in May and June this year, which is illustrated here. Again, averages, not terribly useful, particularly if you lived in Hobe Sound this year. But for the district, May in our area, we had 200% average rainfall. And in June, our area experienced about 150% of the average rainfall. But like I said, this is for the entire watershed. And in parts of Hobe Sound and the surrounding area, there was up to 400% of the average precipitation. This chart here I included to try and illustrate where the water came from to the St. Lucie River. So the gray here denotes the C23, C24 canals and the 10 Mile Creek water flows, fresh water flows into the estuary. This, I'll call it gold, it illustrates the tidal basin inflow. So that's rainfall that just happened locally and didn't come through some canal. And this represents the totality. What's probably most conspicuous here is that the C44 basin runoff is not illustrated. That's because there was no C44 basin runoff. As we talked about earlier, that runoff all went to Lake Okeechobee, which this next slide hopefully will illustrate how significant that was in terms of protecting the estuary. This yellow and gray line and red line illustrate the same thing that this did since May 1st. And I added, this chart is not terribly intuitive because it's really measuring two different things, but the blue line represents C44 basin runoff either to the lake, which is below this zero axis, or back to the C44 canal from the lake, which is above this axis. None of this water, incidentally, went through the S80 because the S80 has been closed since March of 2019. So it's not, this water is a volume of water that went into the estuary, whereas this represents C44 basin runoff that went to the lake. And the reason I wanted to put this on there is to show some relative comparison to how significant an impact that is that the Corps had made that operational change to send that water to the lake. Because what you would do in years past is you'd take that blue line and you'd invert it and lay it over the yellow and gray lines above above the zero axis, to the tune of about 73,000 acre feet that would have been added to the already overwhelmed estuary. And that, to give you some perspective, the C44 reservoir and STA project has an annual capacity of about 53,000 acre feet. So this would have exceeded the treatment and storage capacity of that entire project. And fortunately, it went to the lake where they needed some water and to help mitigate concerns about water supply. Any questions about that? I know it's a little bit counterintuitive. All right. So what happened when that water came from the local basin, C23 and C24? We had 50 billion gallons of fresh water that brought about 3,000 tons of sediment and about 120 tons of nutrient pollution. We would probably call this a moderate to less than moderate freshwater flow event. Still has a pretty significant impact. And anecdotally, we all noticed how the brilliant blue water, like my jacket, in the St. Lucie and particularly as you approach the inlet, how it turned into another plume and at times extended even up to 3 miles out of the inlet from just C23, 24, and 10 Mile Creek and local basin runoff. The upside, I guess, from this year is that we've had no documented harmful algal blooms in the estuary or even in the canals, which is interesting because that's largely fresh water. So when we're going through these things, we're always trying to learn a little bit. Last year, kind of to flesh out a theory that we have that cyanobacteria will not bloom in the estuary without having the contribution from Lake Okeechobee, we did some sediment studies in the dry season when we knew there would be no surface blooms. And we sampled 8 locations in the estuary in the sediment looking for microcystin and microcystis. And the only place we found any persistent microcystis was at the S80, right where it was, fresh water. So it substantiates, and this season seems to substantiate the theory that harmful algal blooms are only going to occur in the estuary when we have discharges from Lake Okeechobee. Current conditions, things are starting to improve. We saw the salinity levels bounce back pretty quickly to fair conditions, and then with every rainfall event, they ebb and flow. Clarity is improving, though it's still not anywhere near where we'd like to see it. And one thing that we're trying to wrap our heads around is why the DO remains so poor in the North and South Fork. That's the dissolved oxygen as a water quality indicator. I guess I would have expected that to recover alongside the salinity, but it seems to have done well in the intertidal area where it's getting more ocean flushing, but has not done so well in the North and South Fork. So Enterococcus is another water quality metric that we track, and we look at 4 different locations. This metric is a human waste indicator, and it is not present in reclaimed water or AA or A biosolids. So largely, the prime suspect for this is septic systems, particularly low-lying septic systems near surface water. I'll point your attention to May 26th, where everything went to red and very significant numbers. May 25th was Memorial Day when we got the first big rain event of the season, and immediately the next day we were experiencing very, very high enterococcus levels at those locations. So it's likely that those are related to these septic systems. These are, on the top of the map is a St. Lucie County map showing septic systems, and then the lower part is Martin County. Well, at this scale, it's hard to differentiate in fine ways, but largely the brown areas are known sewer system connections, and the green areas illustrate known septic. I'm happy to report that this is a 2017 figure from the Department of Environmental Protection, and Martin County now has about 16,000 known septics rather than 18,000, which shows the great progress that the Utilities Department has made in making those connections. And then I would be remiss not to include that the Utilities Department has a very aggressive septic to sewer and the Connect to Protect program that the board has directed them to convert up to 11,000 more of these 16,000 remaining septics. So that's good news and that's progressing very well. And the governor's included a substantial fund for local partners to participate in more connections. So this next slide, and I'll come back to that in a minute, but this next slide I included to show how we've incorporated some new information into how we evaluate comprehensive Everglades restoration program effectiveness, and also performance measures for evaluating alternatives modeled in the Lake Okeechobee System Operating Manual process. So this was some data that we put together with our consultants to submit as a stakeholder comment in the development of a new salinity envelope for the estuary to define what is a healthy freshwater flow to the estuary, and also for evaluating LOSM. So this is really good news for one reason, but there's bad news here as well, and I'll try to cover it quickly. So under LORS 08, the optimum freshwater flow scenario was about 350 to 2,000 CFS. And while the agency that developed, or the organization that developed that envelope, understood that was freshwater flows from all sources, including the C23, 24, 10 Mile Creek, local basin runoff, and the C44, as well as Lake O. When it was put into practice in LORS 08 as a regulation schedule for lake, it was that envelope really only was regarded as a S80 discharge envelope. And so I think it led to some inaccurate measure of impact to the estuary from flows from the Lake Okeechobee. So going forward in LOSM, we have developed this new envelope that defines the optimum conditions as 150 CFS to 1,400 CFS as a whole from all sources. Oftentimes we're running 700 to 800 CFS from non-lake sources, and so the number of cubic feet per second that could be discharged from the lake without triggering a stressful or damaging condition is going to be much, much lower than it has been. So we're encouraged by that, but the discouraging part of this is when you look at the period of record, last 20 years of operating Lake Okeechobee, we have exceeded the new, what we now know is the stressful condition 25% of the time every year. That's 92 days every year we have put the estuary on average in a stressful condition for the ecology, and 70 days out of every year it's in a damaging condition. That's not a great record for the health of the estuary. And you might say, well, 25% doesn't seem like a lot, but many of the other performance measures used to balance management of Lake Okeechobee shoot for one impact in 10 years. We're having an impact every year, up to 25% of the time. So the next slide, while that one kind of discusses like averages and sustained impacts, this slide I know is not intuitive. I'm going to do my best here to bring out the relevant points. What this slide does is it captures the high flow events, and so it measures what you see there in those little diamonds is the highest flow rate of each of the last 20 years since we've had SERP. The 5 red diamonds on the right side are all the highest maximum flow rates in those years, 2008, 17, 99, 2005, 2004, and coincidentally, they're all associated with tropical storm events. However, when you look at the blue diamond, that's the lowest maximum discharge rate that the estuary experienced, and that was 2019. But probably the worst news and the most relevant data point on this is that every 2 years we exceed catastrophically high discharge volumes of fresh water. I don't know of any other performance measure that could survive with violating catastrophic exceedance every 2 years. So these are both data sets and charts that we have provided to try and influence the LOSIM process for our stakeholders. A few takeaways from this year. Every season we're adding to our body of knowledge and trying to learn from acute events and overlay it with what we already know. I try to do a SWOT analysis regularly, and if I were going to do that for this year, the strengths would be that the C-44 basin was sent to the lake. That it's encouraging that the Corps was willing to do that, and we will continue to ask them to do that whenever possible. The lower lake levels coming into the wet season have kept us from having to receive C-44 basin runoff or Lake O discharges. That's very good news, and I would list that as a strength. And then the only other strength I would list that's pretty important is that we've had no cyanobacteria in the estuary, no measured cyanobacteria. We hope to see the whole season through that way. Weaknesses, this is probably also an opportunity, but the Indian River Lagoon South projects, once online, will make a huge difference in mitigating what we're currently experiencing. The C-23-24 projects alone will provide 100,000 acre-feet of additional storage. They'll provide 230,000 pounds of nitrogen removal and about 53,000 pounds of phosphorus removal. Those projects continue to be extremely important to the health of the estuary and our water quality here. And the septic to sewer program, it's commendable. I am proud to be a part of Martin County on that issue. I love to talk about it, and I would implore the board to continue to move full speed ahead on that. And that is pretty much my recommendations as well. We would recommend that we would continue to support funding for IRL South. News on that yesterday, the House developed a appropriation bill that would include $250 million for Everglades restoration, which is a landmark value. When you pair that with what the governor has proposed, over $350 million in Everglades restoration, we're poised to make some huge steps in moving SERP forward and other Everglades restoration projects. Perhaps we could create a video to send to our Florida delegates, a short promotional video that would promote those projects while they're considering how to appropriate federal dollars. And then, of course, we would ask for permission to continue moving forward as aggressively as possible on our utility sewer connection projects.
Commissioner Hurd.
Yeah, The importance of the committee vote yesterday I think it was, it shouldn't be understated. We shouldn't undervalue it. We should celebrate it. It's a huge step forward. I'm sure that the Corps is very, very encouraged to hear that the $250 million has been appropriated by this committee. So now we need to make sure that we understand what the Corps' plans are for that $250 million. Let's be very, very aggressive about communicating with the Corps. Maybe we can get the Colonel here very soon to tell us, because that vote will be coming up. It will, short of a veto, it will pass. So we need to understand what portion of that $250 million is going to go toward the Indian River Lagoon and which projects it's going to continue, complete, or begin.
Commissioner, we have seen the Corps' work plan for fiscal year '21, and currently $150 million is committed to the Indian River Lagoon South. $20 million of that is to finish the C-44 reservoir, and then really most of the remainder of that was committed to C-23-24 stormwater treatment area, which can be fairly quickly constructed in comparison to a reservoir, and so we could see some significant benefits in a short time, and it's largely designed. It's the land has been acquired, and I had made the recommendation to Jacksonville staff that we consider planning a shovel turning for that this fall, and maybe in partnership with St. Lucie County, the Water Management District, and the Corps of Engineers, depending on how COVID has progressed and whether we can do that kind of thing.
Yeah, let's don't lose any momentum, because this is it's a landmark decision yesterday. Let's build upon it.
Commissioner Smith.
Thank you, Mr. Chair. John, I wholeheartedly, first of all, great presentation. I think it always helps that we fully understand what is happening and where the water's going and where it's not going, because that often gets confused. Secondarily to that, I couldn't agree more wholeheartedly that we've talked about it before. We've talked about working with St. Lucie County to get some sort of an event going so that, as Commissioner Hurd said, we just don't lose stride. We keep going and we keep pushing, because that's a lot of money, and it's something that I think for St. Lucie County's side of all this, it'll mean a lot, and once we do get work in the ground, it'll keep on going. So I think to the soonest we can get people together, the better. To not leave anything unturned, that we're not keeping up the full pace on this whole thing. Great job. Thanks.
Thank you.
Commissioner Heatherly.
Great presentation. I echo Commissioner Hurd and Commissioner Smith's comments. And I would just encourage us to continue. We were putting together the working group to work with the City of Stuart and make sure that we're all pushing in the same direction. So I encourage us to share some of this and continue putting that group together so that we're all working together in the same direction.
Commissioner Hurd.
Yeah, also, there was some great LOSUM data in there. How is LOSUM coming along?
It's progressing. The project delivery team has really been struggling to finish up some of the performance measures. The challenge that they have is converting some somewhat obscure factors into flow and stage so that their models can quantify them. We're anxiously waiting. Our performance measure, our key performance measure, the salinity envelope is established. It was approved last week after kind of a long, arduous process, and we're quite comfortable with it. But there's other indices or performance measures that aren't, particularly the harmful algal bloom performance measures. They say they're getting close, but I think once they have those ratified, that they'll be ready to start running some alternative evaluations, and that's where we'll really make the sausage in this process. And a lot of balance is going to take place at that point. So that's where we really have to be prepared to posture for our interests and make sure that balance is achieved, and where we think it maybe hasn't been so well in the past.
Have we one of your slides was we had sampled at 8 different sites for harmful algal blooms. Have we submitted that as part of our data?
We're still, we need to add some, we've shared that with the water quality sub-team, but it wasn't like a peer-reviewed university study. It was, our staff worked with Harbor Branch researchers and put together, we really just wanted to put our toes in the water and take some low-hanging fruit experiments on, and so far, it seems to have revealed what we suppose, but it's probably not 100% defendable scientifically yet.
Oh, I disagree.
Mr.
Thanks.
Mr. Donaldson has something to add.
Just two things I hate to interject. One is on Losum, and our team, which is working on it, is just a heads up that we're getting close to that period where there'll be a high work kind of load on the staff and our consultants to work with you to be prepared for this next step in Losum. So it's just, we've been working on it steadily, but we expect the workload related to Losum to increase here in the coming months. And then there'll be sort of once they start producing these model results, there'll be a lot of input. So we will be coming back to you kind of with an update on that. And then lastly, I think related to your question about the sampling was, I think one of the things that John talked to me about in his presentation, which he didn't mention, was it's very important to note that the lake actually has a hazardous algae bloom ongoing right now. And you're not seeing any hazardous algae bloom in our own canal with the same, with the nutrient loading. And I think one of the things that was, to me, and the scientist side of things, if I could nerd out for a second on the study that you referenced, was really looking for evidence of microcystin. One of the assertions is that the algae we're seeing is homegrown. Once it got introduced, it creates these little cysts that sink into the soil, and then they will bloom again and have nothing to do with the lake. I think, at least in our initial study, we did not find it in the estuary at all. And so it's certainly our first stab at this is the evidence is that the estuary is not producing its own hazardous algae bloom. The organism is coming from the lake. Now, we didn't do a study in the canal, but we're certainly seeing evidence of the same warm water conditions, freshwater runoff, no algae in the canal, and yet there's a big algae bloom in the lake. So those are just important pieces of information that I think it's good for all of us to know.
Commissioner Smith.
Do you mind if Chloe comes up for a minute?
Sure.
Seeing as you're here. So Chloe, as you're coming up, I'm just kind of curious on the status of Washington these days. Are the staffs back in D.C. and have you talked to Fowler? Because I think at some point, maybe with this, certainly with the money that has been put into the budget, that there ought to be, if the staff are there and people still aren't traveling, maybe we could set up one of those team things that we did with the Coral Reef program, that we assign different members to a team and we covered a broad spectrum of people to make sure we remind them about the funding and where it's got to go and how it's got to happen. So just kind of curious what your take is on that.
I think it would be more feasible to do that. I don't believe that people are walking the halls in DC. I know Fowler's representing us well by constant communication the best he can virtually. But I think that's a great idea that we can do some kind of team meeting where we meet with everybody involved just to touch base with the staffs at the very least, if not the legislators themselves.
And three things I think I would focus on for that if the board was inclined to want to do this again. One is that certainly the funding that John has pointed out. I think details about what is occurring and what's not occurring relative to the lake and so on, just to back up where we might be going with all that. And then number three is certainly the importance of C23 and 24 to reinforce that and make sure that stays on message and that we just don't get off that message until they actually start breaking ground and start working on it, just as a thought. Thanks, Chloe.
Okay. With that, thank you. That was very thorough. Wonderful.
You ready to
Well, I am. I'm just, Mr. McChrystal sitting back there, he would like to do a 505 comment. Is that appropriate now, or we have to do that when we get back?
We have to go back after the,
But they could take his comments now.
sure.
Yeah, you can take
Okay.
his comments now if you want to.
Okay, sure. Come on, Mr. McChrystal.
And as he's coming up, what I would recommend for us is go ahead and take a break, and then we'll meet next door in Chambers. And that way we can distance ourselves and have your executive session in there rather than going in that little conference room in the back.
Okay.
Just a couple things. First, you are all to be commended for your handling of some difficult topics lately, especially the mask issue. It was great fun to watch, actually, and just a couple things. The Patriots, they've got a point. So in today's world where it's, hard to know what to believe and what to trust, and the information is even harder to verify, you all did a great job. Where I think you got it right was you got the job done of getting more masks out there without ever having anyone in our county ever get a criminal record for non-compliance. So good job there. And hopefully you hold the medical community's feet to the fire on those numbers that you were asking for, Harold, and see what happens in 30 days from that when it started. One thing I'm really interested in is some great details on why the $5.2 million for the golf course project doesn't seem to be enough anymore. So Mr. Abate, I invite you to come forward with some great details on what's going on there, especially as we go into the budget. And it's my opinion that the whole thing rests on a complete job. Just breaking even is going to rely on the complete project being done. Absolutely. So, again, I'm disappointed and very interested in why we couldn't get it done for 5.2. So if the devil's in the details, I think the public deserves to know them. Okay, thank you very much.
Okay, thank you. Okay, so now we're going to take a break, and then we're going to reconvene our
Executive session.
executive in the chambers, and then we're going to come back here.
You have to come back here to adjourn, yes. And you might want to take commissioner comments.
So,
What time are you
meet at
gonna
a
meet?
quarter till?
Yep.
Oh,
Yeah, somebody does, right?
Oh.
To see what we're going to do.
Oops. Yeah. So we will be going into executive session here to discuss our IAFF labor negotiations as allowed by Florida statute. And in the meeting, we will have Mr. Matthew Graham, your HR director, the 5 commissioners, myself. You'll have also Mr. Matt Resch, who's the finance, the CFO kind of fire rescue, and then Chief Schobel, your fire chief, will be in there, and Elise Elders and Sarah Woods. So all those individuals will be part of that discussion.
And we can social distance with all those people?
In the chambers?
Oh, we're not going to be in the conference room?
No, in chambers, that's why, because that conference room's too small.
Okay,
Harold, what time do you want to be there?
quarter till, that gives us 10 minutes.
that's good.